Good morning, friends. Today we will study about business laws through some multiple choice questions. So let's get started. Let's start with the first question. Who is called a buyer? Option A. A person who buys or agrees to buy goods. Option B. A person who buys goods. Option C. A person who agrees to buy goods. Or option D. Who offers consideration. The correct answer is option A. That is, a person who buys or agrees to buy goods is called a buyer. The next question is, when the Sales of Goods Act became effective? Option A, 1st July 1930. Option B, 1st July 1390. Option C, 1st July 1940. Option D, 1st July 1950. The correct answer is option A, that is 1st July 1930. But what does Sales of Goods Act means and applies to? Let's find out. The Sales of Goods Act was initially called the Indian Sales of Goods Act and was implemented in 1930. It is basically a mercantile law which came into existence on 1st July 1930. This act was enacted for setting up contracts where the seller transfers or agrees to transfer the title in the goods to the buyer for consideration. Under this act, goods sold from owner to buyer must be sold for a certain price and at a given period of time. This particular act was amended on 23rd September 1963 and was renamed the Sales of Goods Act 1930. The next question is, the goods identified at the time of sale of contract is option A, specific goods, option B, future goods, option C, certain goods, and option D, uncertain goods. The answer to this question is option A, that is specific goods. But what is the exact definition of specific goods? Let's find out. Specific goods. The definition of specific goods is given in Section 2, Clause 14 of Sales of Goods Act. As per the section, these are those goods that are identified and agreed upon when the contract of sale is formed. For example, if one has to sell his mobile phone online, then the seller puts an advertisement with its picture and the information. A buyer agrees to the sale and the contract is formed. The mobile in this case is a specific good. Let's move on to the next question. Who is the seller? Options are option A, a person who sells or agrees to sell goods. Option B, a person who sells goods. Option C, a person who agrees to sell goods. And option D, who offers consideration. The correct answer to this question is option A, that is, a person who sells or agrees to sell goods. Let's move on to the next question. What do you mean by constructive delivery? Options are A, right of delivery of possession of goods. B, conditional promise. C, symbolic possession. And D, none of these. The answer to this question is option A, that is, right of delivery of possession of goods. The next question is, the Sales of Goods Act implies to A, movable property, B, immovable property, C, invisible property, or D, None of these. The answer to the question is option A, that is movable property. The next question is, what does a good includes? Options are A, standing crop, B, land, C, building, or D, open plot. The answer to the question is option A, that is standing crop. The next question is, the agreement to sale creates the right of dash. The options are A, right in personam, B, right in rem, C, right in things, or D, all above 1, 2, 3. The correct answer to this question is option A, that is right in personam. What does a right in personam and right in rem means and implies? Let's find out. Right in personam. A right in personam gives the person right against one person or a party to a contract. It generally corresponds with a duty imposed on said person or a party. Right in personam is a legal maxim that arose from the Indian Contract Act and grants a right in a personam or to a specific person to the parties of a contract. So the parties of a contract have these essential contractual rights all against each other. That is just in personam. So basically, right in personam is a right against any one or a specific person. That is the person that have entered into a contract with each other. Let's move on to right and rem. A right and rem, as per law of the land, means every person entering into a contract has right in rem. This is a right available to him or her against the entire world. It protects a person's property from the entire world. It is basically a negative right. This right is available to an indefinite or open class of people, that is available to all. So basically, right and rem gives right to one person against every person in the world. Right and rem and right and personam are opposite to each other, where one right and rem give rights to only a person to act against only one person. Right and rem gives it a wider perspective by giving a person right against the entire world. So next question is, what is FOB contracts to? Options are free on board, B, with value on board, C, on board with installment, or D, on board with trolley. The correct answer is A, free on board. What does the legal maxim caveat emptor means? Options are A, beware customer, B, beware seller, C, beware agent, and D, beware trader. The correct answer to this question is option A, that is beware customer. The next question is, the right of unpaid seller is dash. Options are lien, B is mortgage, C guarantee, or D bailment. The answer to this question is option A, that is lien. Let's move on to the next question. Which section of the Negotiable Instrument Act 1881 deals with negotiable instruments? Options are Section 4, B. Section 18, C. Section 6, or D. Section 7. The correct answer is Section 7. So let's discuss and understand what does Section 7 of the Negotiable Instrument Act is. Section 7. This section basically defines the concept of a drawer and a drawing. As per this section, the maker of a bill of exchange or a check is called a drawer. The person thereby directed to pay is called drawee. This means that a person who writes a check or a bill of exchange is called a drawer, and the person against whom it is written is called drawee. When in a bill or in any endorsement thereon, the name of any person is given in addition to the drawing to be resorted to in case of the need, such person is called drawee in case of need, or the acceptor. After the drawee of a bill has signed upon the bill, or if there are more parts thereof than one, upon one of such parts and delivered the same, or given notice of such signing to the holder or to some person on his behalf, he is called the acceptor or the acceptor for honor. The clause 2 of this section says that when a bill of exchange has been noted or protested for non-acceptance of a better security and any person accepted for the protest for the honor of the drawer of any of the endorser, such person is called acceptor for honor or the payee. Person named in the instrument to whom or whose order the money is by instrument directed to be paid is called the payee. So let's talk about the next question. Which of these is not a negotiable instrument according to Negotiable Instrument Act 1881? A. A check. B. Bill of exchange. C. Currency note. Or D. Promissory note. The answer to this question is currency note. Let's get to the next question. The Section 4 of the Negotiable Instrument Act deals with options are option A, check, option B, promissory note, option C, Hyundai's, or option D, bill of exchange. The correct answer to this question is option B, that is promissory note. So let's move to the next question. Parties to bill of exchange are called A. Drawer, B. Drawee, C. Payee, and D. All of these. The correct answer is D. That is all of these. The next question is, a promissory note is A. A conditional order to pay, B. A unconditional order to pay, C. A conditional promise to pay, or D. An unconditional promise to pay. The correct answer is option D. An unconditional promise to pay. The next question is, which section of the Negotiable Instrument Act deals with check? A. Section 6, B. Section 5, C. Section 118, or D. Section 7. The correct answer is A. That is Section 6. The provisions of the Indian Contract Act overrides which of the following? Option A. The provisions of Hindu law. Option B, provisions of Mohammedan law. Option C, usage or customs of trade. And option D, all of the above. The correct answer to this question is option C, usage or customs of trade. So, the next question is, in case of a promissory note, there are how many parties? Option A, 3 parties. Option B, 5 parties. Option C, 2 parties. And option 4, 4 parties. The correct answer to this question is option C, that is 2 parties. Let's move on to the next question. Which of the following statement qualifies a promissory note? Statement 1, I promise to pay Shyam rupees 50,000 on demand. Statement 2, I promise to pay Shyam rupees 5 lakh along with my car on demand. And statement 3, I promise to pay Shyam rupees 50,000 and rest of my fines on demand. So the options are option A, only statement 1, option B, only statement 2, and option C, only statement 3, and option D, both statement 1 and statement 2. The correct answer to this question is option A, that is only statement 1 qualifies for a promissory note.